Foundations of Property Law. We're into week 8. Thank you very much for joining us for the live session. If you're watching this as a recorded session, please do consider joining us for the last 4 weeks of the term. So we're now getting to the stage where I trust you're really gaining some momentum in your studies. We have some deadlines that are starting to loom, and the second assessment is due on Thursday, 21 May at 11:45 p.m. So you have that assessment. I trust that you've read it, you're working on it, and in all likelihood, you're probably well advanced in it. If you're not at that stage, I encourage you this week to make your special task to make a concerted start on that assessment piece. I don't want you to write it this week, but I want you to be in a position where you understand what it's about. You've started to collect some raw materials, hopefully primary sources of the law wherever you can, and you've started to map out a procedure or an answer for the problem using, hopefully, the toolkit, for want of a better term, that you've created in the first assessment. So please start to work on that in a genuine method now. You'll also note that I have announced in the last couple of days the date for the take-home paper. I'm sorry for the delay, but I'll just say that unit coordinators needed to be given the okay. The law school quickly identified dates that could work as best we can make them to spread out the load between subjects, units in the law school. But for better or for worse, Foundations of Property Law, the take-home paper I will release on Thursday, 11 June at 6:45 p.m. or thereabouts, and it's due by Friday, 12 June 2020 by 11:45 p.m. There's no whereabouts with that time. That time's strict. So please ensure that you make arrangements now, this week, to be able to sit that exam during Thursday evening, Friday, and Friday evening. My personal philosophy with take-home papers is, wherever possible, introduce 1 day and 2 evenings so that those people that are working during the day have an opportunity at least to work on the assessment over 2 evenings. This is, as you might expect, a direct replacement for the examination, which I'd written, of course, before COVID hit us. And I can tell you that what I've done is essentially kept the same testing regime in the take-home paper as it was going to be in the invigilated examination. So it's written to enable you to answer the problems, the entire paper, in handwritten form in 2 hours. So in the sense that you've now got 29 hours to complete the task, it's much easier, but it's different. So if you find that you only have limited time during the period of the window that's available, don't stress, because otherwise you would have been handwriting it in 2 hours anyway. If you've got longer than that, fine, and good luck to you. Some people will spend much longer than others, and that's just the way it is. But you won't have to. It's pretty straightforward. And over the next few weeks, we'll talk more about that. And in week 10, I'll release some specific guidance about what's in that take-home paper. So are there any questions before I move on in terms of the second assessment, the content, the form, the material, when it's due, or the take-home paper? All good? All right. Last week, we made a start on topic 6, fragmentation of property interests in land. And we identified the things that you need to discover and learn in terms of the relevant emphasis. There've been a few key thoughts in this unit, but probably if we had to identify one specific key thought, it would be, and I forget who mentioned this last week, and in our live session, but think of property in terms of a bundle of rights over things that are exercisable against others, rather than this concept of ownership. And can anyone tell me the authority for that proposition, or an authority for that proposition? Yes, Ivan? Can't hear you there, Ivan. Sorry.
Can you hear me?
Now we can hear you, yes.
Oh, sorry. Nablico, 1971, and I've forgotten the Aboriginal name of the applicant. But that's the case where
Okay.
bundle of rights was described.
Thank you very much. It's not the one that I had in mind, or two that I had in mind, but thank you for that. The two that I had in mind, and I'm not saying these are better than Ivan's choice, Telstra Corporation against the Commonwealth, 2008, 234 CLR 210. And you'll see in that case, the High Court referred to an earlier High Court decision of Yanna and Eaton, 1999, 201 CLR 351. Whatever it is, given that's a key thought, in your toolkit, as I'm describing it, you should have a reference to that, have the citation handy, maybe a hyperlink, have that something that you can introduce, either even if it's in a footnote, but just something in the commentary, generally speaking, when you're talking about property, the rights of property holders. So if you like, property is the legally endorsed concentration of power over things or resources. Now, property can relate to ownership in the traditional sense. When we're talking about personal property, chattels, or real property, land. But we also need to think of it in terms of another way of fragmenting it is the way in which the property rights, the bundle of rights, if you like, may be exercised in the sense of property rights either being in rem or in personam. Now, I make an error here from time to time of always thinking about in rem as relating to real estate. It's much broader than that. When we talk about in rem, it does relate to both real property and personal property. It's just that I tend to associate the cases which are around that concept of in rem with real property, but it can relate to both. So when we talk about property rights operating in rem, what does that mean? Can anyone give me some indication of the meaning? If you watch it, this is a recorded session. Raise your hand, answer the question out loud. All right, so when we talk about in rem, we're really talking about enforceability. And enforceability against, Natalie, were you just about to answer this?
No, sorry, I just joined the Zoom session.
Oh, okay, thank you.
I had problems dialing in, so yeah.
No, thank you for joining us. But Nicholas did answer the question correctly. Thank you, Nicholas. It means it's enforceable against the world. So when we talk about the bundle of rights relating to property, and we're talking about this concept of in rem, we're talking about something that's enforceable against the world. So in rem rights are property rights which are enforceable against the world. Contrast that to rights in personam, which in the context of a judgment binds only the litigants. So a proceeding in personam is one where relief is sought against or punishment is sought against a specific person. So when we look at cases, on the face of it, we're dealing with something that's in personam, meaning binding the litigants, but the effect of the bundle of rights may be that the rights that attach to property bind are available against the entire world. So when we talk about in rem, it's a Latin term. It means against a thing. It attaches to the thing, and the rights relate to every potential rights holder. And it can be useful in the context of trying to think of it as determining the priority of rights holders, because more than one person can have an interest in a particular property in rem. So it may be that there are competing interests, which we then have to consider this question of the priority of competing interests. Now, a common term that you'll come across is that which relates to estates or interests. So when we talk about an estate, it derives from the old feudal system in medieval England, and that related to the feudal system of tenure, T-E-N-U-R-E, so which is the doctrine of tenure. So it describes the nature and effect of proprietary entitlement to land. So when we're talking about land, you'll see some terminology: freehold land as opposed to leasehold. And generally, if you have a leasehold estate, your interest is less than freehold. And if you have a freehold estate, it's essentially as good as you can get, but it's not absolute in terms of ownership. But it's a bundle of rights which is quite extensive, and it operates in rem. And when you have freehold estate, it can either be generally in fee simple or as a life estate. So when we speak about an interest in land, we're referring to the quality and the extent of the person's rights in the estate to that land. So in law, we don't talk so much about ownership, at least not in a technical sense. We talk about these bundle of rights and the entitlement of the holder of the freehold to certain interests and rights that are available to them. Now, of course, we've discussed in the context of other topics in property law, and we'll talk now in the context of fragmentation, another way of fragmenting property. Property may be fragmented as a result of the ownership through being proprietary or being in a mere equity. So the legal versus the equitable comes into it. So a mere equity is a personal interest that someone may have, which can be enforced through some form of equitable remedy. So there are different ways of categorising a proprietary interest in relation to property. Now, I'm talking real property and personal property, and it indicates that the person, the proprietor, holds ownership, for want of a better term, which is a proprietary right. Now, we need to contrast the proprietary rights against contractual rights is another way of fragmenting property interests. So, for example, a licence to enter upon property is a contractual right. Can anyone think of a case that goes between contract law and property law that deals with this concept of an entitlement to be on property subject to the terms of a licence agreement, and a case that describes the extent to which the licensee has an interest in the property, if at all? Anyone?
I don't get the name of it, but I know the case you're referring to. It's the one where he went through the turnstiles, isn't it?
Yes, that's the one.
Was that in Sydney?
I think it was.
Yeah, I know the one you're
Yeah, it was in Rose Hill, at Kywell and Rose Hill.
That's
Rose
the
Hill.
one.
I think Rose Hill's in Sydney.
I think it is. I think so. All right, so that's the one.
I can
Now,
confirm it's down the street from me.
Oh, is that right?
Yes.
So Amy knows exactly where that is, so thank you. So the reason I mention that is that that's a useful case to keep in your toolkit to bring out in an answer when you're trying to distinguish between proprietary versus contractual rights. But again, remember that proprietary interests can be legal, can be equitable. We talked about those last week. And generally, a proprietary interest in rem is one that's enforceable against everyone, against the world. Now, another way of fragmenting property is through this doctrine of estates. It's common law, and it provides, at common law, there was provision for successive interest in estates. In other words, multiple interest holders might be entitled to possession of property, some presently and some in the future. So when we talk about estates, it can be fragmented in a temporal sense in terms of time, now or in the future. And the doctrine of estates is very closely linked to the doctrine of tenure that I mentioned earlier. And the doctrine of tenure, again, it's common law, it's very historically based, but it talks about or describes how a person holds generally a freehold estate. So the doctrine provides for clarifying the interest in land according to the conditions upon which the land grant was made. Now, I know I'm throwing a lot of terms and they seem to cross over, but that's just the reality. And this is where I'll talk about the Property Law Act again. This could have been simplified, but it's not at the moment. And that's why when you're reading laws around property rights, it seems to be that there's dozens of different ways to describe different interests in property and different remedies that are available. And the fact is that that's just the way it is. So that's why you need your flow chart. That's why you need your little go-to descriptions and cases and sections of Act. So what do we make of all this? Well, in reality, in terms of practical application, we do come across some of these words on a regular basis. So, for example, estate or tenure, we hear about that. So it's important to understand how these interests in land operate in a practical sense. So the most common thing to think about is what we call fee simple. That's common, and that you'll need that. So you'll need to understand what we mean by fee simple. Lawyers regularly talk about that. Another way of describing the estates and the tenure is a fee tail, T-A-I-L. Now that's rarely considered, so that's not important in practice. In Queensland, that type of estate has virtually been abolished, and fee tails can no longer be created, and existing interests were converted into fee simple. So if you're thinking about, you're looking at fee tail, trying to work it out, don't worry about it too much. It's not really practically important. It's not like fee simple that is. Life estates, that's important. We see that quite often. And leasehold estates, that's important as well, as you might expect, in the context of both residential tenancies and commercial interests. So fee simple is the best type of ownership that you can get, but it's not absolute, as we discussed. It doesn't cater for minerals and petroleum, for example. They're reserved to the Crown in the original deed of grant. In the text, another fragmentation topic relates to determinable and conditional interests. Now, these are not particularly important in practice. So if someone wants to impose conditions, it's more likely done through a mechanism like a trust or perhaps a company than by the creation of a determinable fee simple estate subject to a condition subsequent, for example. We don't really do that. So I don't want you to worry too much about determinable and conditional interests. But do, when we get to that stage in your studies where we start to talk about trusts and companies, that is very important in a practical sense. Has anyone done equity, or are you doing equity at the moment, studying equity? Okay, with Alex? Okay, I've taken that unit previously. It's a good unit, and I'm sure Alex is doing a very good job. So she'll be talking to you about done equity, currently on trusts. So you'll be hearing all about trusts in detail. Now, there is a thing called the Doctrine of Waste. This is of some practical significance in succession law. So the law tries to, I mentioned earlier that it is possible to have interests in property which is temporal in its nature. Someone has an interest presently, someone has an interest in the future. So given that that is the case, the law tries to provide a balance between the right of a person presently entitled to possession, for example, a life tenant, against those that may have or will have an entitlement to possession in the future, which is the reversion, that which is left once the life interest has come to an end. So it's not something you need to worry about too often. And when you read about this, you might note that a lot of the cases are from the 18th and 19th century. And that's a dead giveaway, in my mind, that this is something which is for you to understand in a general foundation sense, but not particularly relevant, in that if it was particularly relevant, we'd probably be talking like we did the last week and the week before about legislation that came out fairly recently. So don't worry too much about the doctrine of waste. In the commentary, there's also some statements about legal future interests. And there's a distinction between reversions and remainders, vested in contingent remainders. Now, it's probably fair to say there's little practical application outside of a will, although in that context, reversions and remainders are particularly common, and the remainder can be contingent. So there's a tie in there with, when we talk about remainders, we often talk about a contingent remainder. So what does all that mean? Well, it means that, firstly, the contingent part means that there's some sort of precedent condition in addition to the expiration of the prior estate to be fulfilled for the remainder to become possessory. It's a lot of words, so you can break that down. So a remainder means something that comes to an end, something that comes into existence in a practical sense after something presently existing has come to an end, like a life tenancy in favour of someone. But it might be a contingent remainder in that there may be some further condition applicable before that takes effect. I'll give you an example. I mentioned that we see this sort of thing in wills. So you can maybe picture this type of a clause built into a will. Someone wants to cater for their disabled child by allowing them to live in the home, but they don't wish to give them the ownership of that home. So they might say to, let's say, Bill for life, talking about the property, with the remainder to go to Betty. Let's say Betty's currently, 16 years old, or her heirs, provided Betty shall have reached the age of 21. Now, you may not want to do that, but that's the sort of clause. So you can see that it's a contingent remainder in that, firstly, Betty doesn't receive the property until Bill has passed on, because Bill has the interest for life. but then Betty can only receive that property as a remainder contingent upon her reaching the age of 21. So it's a contingent remainder. Oh, I hope that makes some sense. Any questions? It makes more sense when you're doing a will. But you will read about this, and that's why I want you to have these definitions clearly in mind, so that if you come across a term, you think, what does all that mean? How does that tie in? You've got a quick reference guide that works for you. So a vested interest is one to which a person is presently entitled to possess, or one that they're bound to take into effect at some future time. So as opposed to a vested interest, as opposed to a contingent interest, which may or may not take effect in possession because the contingency must be met before the vesting occurs. So there's another term to do with fragmentation. The contrast between that which is a contingent interest and that which is a vested interest. What does it mean in practical terms? Vested means you've got the ability now, it's not subject to anything. A contingent interest means there's a precedent in the way, there's something that needs to be satisfied before you can move on and say, I now have a vested interest. And we had comment, I think, saying succession was, Shona said, succession was great. Please consider taking that as an elective. And I totally agree. I mean, particularly if you had, if you wanted to work as a solicitor, even if it wasn't your chosen field, I'd strongly urge you to consider succession law. And it's a good, interesting subject. Term 3 in summer. All right, so that's the difference between the vested and the contingent interest. Now, we've been talking to some degree about future interests when we talk about remainders and we talk about reversions. And I suppose, what is the difference? So a remainder gives the title back to the grantor, a reversion does not, is the technical difference. Now, future interests in land is section 55 of the Land Title Act. You may register a life interest and a remainder. The registrar may record in the Freehold Land Register an interest in a lot for life and an interest in remainder in the way that the registrar considers appropriate. So it is possible to register a life interest in property on the title. Those of you that have studied equity or your trusts, or you're studying that now, you may have come across the term the use, USE. The use, again, it's so much of this relates to English law. The use was a precursor to the trust, and the use provided the introduction to trust law. So I mentioned the importance of trusts, and there is a tie-in between trusts and property law. So the essentially feature of an interest under a private trust is, and I'll quote from a source on this, this is APL. I think it's in your reading guide, citing Jacob's Law of Trusts. I don't have the page, I'm sorry. But the trustee must be under a personal obligation to deal with the trust property for the benefit of beneficiaries, and this obligation must be annexed to the trust property. The obligation attaches to the trustees in personam, but it is also annexed to the property, so the equitable interest resembles a right in rem. So that's tying in trusts with the concepts of in personam and in rem. Now, again, I don't want to delve too much into trusts, but you might come across, or you will come across, the distinction between a fixed trust and a discretionary trust. So a fixed trust is, as the name implies, set in a certain way, but a discretionary trust allows for a degree of flexibility. Now, this is relevant to property law and fragmentation of property, because when we talk about this bundle of rights, this interest that people may have in property, it may be that they have that interest as, for want of a better term, the owner, or it may be that they have the interest as trustee of a trust. In other words, for the benefit of someone else or some other group of people. So from a tax minimisation perspective, the use of discretionary trusts has been widespread over a number of years. Now, the benefits have been eroded in a practical sense through legislation, but essentially the way in which a discretionary trust works is this. Once established, the trustee, for want of a better term, the manager as well as the legal owner, gets to decide certain things, mostly about the income. So income that's generated in the trust can then be distributed in a discretionary manner, that is, at the discretion of the trustee, year by year, so that money can be spread or can be provided to one person or a number of people, and that discretion can change so that this year A, B and C may receive a benefit from the income, whereas next year D, E, F might receive the benefit. It's totally at the discretion of the trustee. And in practical sense, it operates as a way of protecting assets from creditors, but also to provide some degree of flexibility in terms of income planning and strategies to minimise tax. Any questions then about discretionary trusts? And you can see how that might tie into property law, in that a property might be owned by an individual or a company as trustee for a discretionary trust. Any questions, comments? All good? All right, we'll move on. So when we talked about uses as the precursor to trusts, that all came about as a result of the operation of the laws of chancery. And the law of courts of chancery basically looked after rules of equity and the enforcement of equitable remedies. So when we talk about trusts, it's linked to uses. When we talk about equity, it's linked to the Court of Chancery. And the cestic use, you may have come across that as a Latin term, is another term for beneficiary. So note the use of the word use there. So cestic use and cestic trust are more or less interchangeable terms that you'll come across in those more specific subjects. Now, another way of fragmenting property in Australia is as a result of Mabo and the Native Title Act. So with the decision in Mabo, we had, and the citation, of course, one of the citations, 1992 HCA. This is referred to in your text at 3.4. Now, there's some comments there about the nature of land tenure. And we need to talk about radical title as a way of fragmenting property. Now, the notion of radical title enabled the Crown to become paramount lord, if you like, to follow through the English theme, of all who holds tenure granted by the Crown, and to become absolute beneficial owner of any land that was not alienated. So radical title ties into that. And that it also ties into the doctrine of tenure. So the doctrine of tenure applied to every Crown grant of an interest in land and not to the rights and interests which do not owe their existence to a Crown grant. So what is radical title then? Well, again, if we look at a definition, I've got one here from the Australian Legal Dictionary, the Oxford Australian Legal Dictionary, and it says, radical title is the comprehensive and fundamental title to or ownership of land and waters assumed by a nation state in international and associated domestic law upon its colonisation and acquisition of sovereignty over a territory. So that's what we mean by radical title. So it is, if you like, as best we can describe it, absolute ownership. So that's why we talk about people that, own property, own 3 Smith Street at wherever. They have fee simple, but they don't have radical title. So in Mabo, the court considered radical title, and it held that the colony territory was inhabited by Indigenous people that maintain this legal and customary rights and interest in land and the waters. So that is the native title. And the Crown's radical title did not extend to absolute beneficial ownership of those lands and waters to the exclusion of the rights and interests of those people. So you can see that on the one hand, one way of fragmenting property is to consider radical title in favour of the Crown as being, for want of a better term, absolute ownership. Now we have Mabo, we have the distinction between radical title and native title, and the Mabo decision essentially said that the Crown's radical title does not override the native title. So the rights and interests serve as a burden on the Crown's radical title, though they may be subsequently extinguished by a valid exercise of sovereign power. So the court's determination that native title was enforceable over land meant that all acts of extinguishment of native title after the enactment of the Racial Discrimination Act of 1975 were unlawful if the traditional owners were treated less favourably than non-Indigenous interest holders. In other words, if they were not compensated where their rights were extinguished, or if they were not afforded the same procedural rights as non-native title owners, they could establish unlawful discrimination. And that's the basis upon which the High Court came to its decision in Mabo. It was all because of the Racial Discrimination Act in 1975 that made it possible. Oh, I'm talking a lot. I'm doing that, I know, but I hope that's making sense. So what I urge you to do is try to set this out in a way that makes sense for you so that you can see the hierarchy, the terminology, etc. Now, you may come across a thing called the rule in Shelley's case. You can pretty much ignore that. Have a look at section 28 of the Property Law Act, Queensland, 1974, and it talks about the rule in Shelley's case as having no effect. Also, when we're talking about things that the Property Law Act did abolish, could have gone further, so it did make some progress in getting rid of some of these antiquated thoughts and ideas, but section 30, subsection 1 of the Property Law Act abolished the rule in Purifoy and Rogers. That was a 1600s case. And section 7 of that same act abolished the statute of uses, which was passed in 1535. So it took till 1974 for us to get round to abolishing that. All right, so that's it for topic number 6. We'll move on briefly to topic 7, but not before we talk about a few general things, just as a break. So firstly, collaboration. You're allowed to collaborate, but you're not allowed to collude. A good idea is for you to undertake some research if you haven't already, so that you get a good idea of what's the distinction. And when you're discussing with your colleagues in study, you'll have a good idea of whether you're lawfully collaborating as opposed to colluding. So have a look at CQU policies. If you haven't found it, I'd recommend you look at, for example, plagiarism procedures and student misconduct and plagiarism policy. Now that's not exhaustive, but there are other issues around collaboration. So independently of this unit, have some other go-to document or source material so that you can put in things of a more general nature. Now, speaking of more general nature in the context of your study, if you've worked with me in the past, and I would have mentioned, I'm sure, and I may have mentioned already in this unit, the importance of reading the questions that are presented to you in an examination or an assessment. And the first word is usually very important. For example, if you're asked to interpret something, that's different to if you've been asked to analyse something or to evaluate something or to describe something. They're all slightly different terms. They're not synonyms. So you need to have some way of identifying that in your general document for all of the units. So when we talk about interpret, we're testing your ability to understand. So interpretation is the ability to identify the surface meaning of the object. And I guess it's, can you accurately explain the meaning of each of the terms and phrases and the meaning of the whole thing or the whole rule? So that's interpret. Analyze technically means the ability to identify hidden features. So to some degree, you should always undertake an analysis by calling, if you're dealing with a problem, you might say, well, the problem on the facts as presented are not fully comprehensive because there may be this issue that's important. An easy one is, when did this occur? And some of you picked up on that with the second assessment, for example. But analysis is the ability to understand or identify the hidden features. Evaluation is the ability to assess. So it's your ability to assess the object of the critique by comparing it with other set criteria, for example, and then identify whether this particular thing does or does not meet the criteria. That's what an evaluation is. Explanation is just your ability to communicate results in an effective, persuasive manner and your critical thinking skills. All right, of a more general nature as well is quality writing. I can summarise it by this terminology: communicate simply and effectively. So quality writing involves you being able to convey the message in the most direct manner that you can for the benefit of the recipient to receive and understand the material quickly. And remember, of course, that when you're undertaking your studies, there is not just one threshold learning outcome. There's 6 of them. You might remember this from Introduction to Law. And you might think in undertaking your studies that it's all about knowledge, and it's not. That's one of them. That's the first one. But the 6 threshold learning outcomes which guide the way in which examiners mark assessment is, sure, number 1, we want to know that you've got the knowledge, but number 2, and this is often overlooked in assessments, ethics and professional responsibility. So it's always important that you consider whether there are any ethical or professional issues that come to mind in answering a question. So if you're answering one of my questions, if you can identify something to do with ethics that might be relevant, please do so. If you can think about something to do with professional responsibility, for example, your ability to comply with practice directions, then do that. So that's number 2, ethics and professional responsibility. Threshold learning outcome number 3 is thinking skills, which is why I mentioned things like evaluation and analysis. It's not just your ability to repeat that you've got the knowledge, but how well can you think through things? So the whole idea of this toolkit that I've been calling it relates to your ability to undertake research, get the knowledge, but then to put it into a way that demonstrates your thinking skills. Number 4 is research skills. So that's why I keep emphasising, have your go-to source, whether it's Westlaw, LexisNexis, Jade, whatever it might be. Number 5, communication is threshold learning outcome number 5. So communicate simply and effectively. And number 6 is self-management. So that's to my mind, your ability to look ahead, identify where you need to be in 5 weeks, for example, and work back from there by building a program. So as graduates of this university, you're looking to demonstrate your ability to solve problems, and you do that through your research skills and your communication skills. So always develop these shortcuts, templates, guidelines, checklists that will help you to answer the problems well and avoid a situation where you think, well, I forgot to mention something. Whereas if you've got good flowcharts, templates, checklists, dot points, whatever it might be, that will help you. And just finally on communication, if I could talk briefly about oral communication and written communication. Firstly, in oral communication, as you're completing your studies through the university, think about the tone of your voice, think about the pace at which you're speaking, and also, importantly, and this is very often overlooked, think about your breathing. So make sure that if you're about to embark on something of a monologue, you take sufficient breath to see that through to the end. And don't underestimate the importance of your acting skills. We can all act, can't we, to some degree? We're all good at that to some degree. We do that all the time, don't we? With people, children, bosses, I don't know, whatever it might be. But use your acting skills in law because it is important. If you're finding yourself in court, do think firstly about your space in court. So make some space for yourself, not American style. Don't overrun the courtroom, running all over the place, but within your area, have your feeling of space. Stand up straight. Wait for just a moment before you start to speak because you've got to make sure that you've maintained eye contact with the court. And if you can, work on an excellent opening sentence. Do speak slowly. And remember, of course, that if you're trying to argue a case, to some degree, you're relying on your acting skills, but also you're a storyteller. So the court, and think of this, the court is always interested in what you've got to say. The court wants you to do well because it makes the job of the court easier. And naturally, we like to see people do well. So when you make a point, make it a key point, just pause for a moment and exhale while you do that. I'll give you an example. So if you're trying to make a point and you said, and then his mother died and he went off the rails, that's emphasising it. Whereas if you just run it through and then his mother died and he went off the rails, it doesn't quite have the same effect. So think about those issues. Now, with your written communication, it's important that you plan your thoughts, maybe consider using headings, have a professional presentation, make sure it's well referenced. So you've got to know you're referencing. Make sure that what you write is logical in its nature. Generally, if you're in doubt, use short sentences. Make sure you understand the difference between the active and the passive voice. I'm sure you all do now. Try to be concise, write plainly. And a short document will often take more time to prepare than a long, rambling document. So writing well is something which is aimed at the recipient and try to convey what it is that you want to in an efficient manner. Have a look at my sample document. I mean, we've all got our little things. I try to encourage you not to end a sentence with a preposition. If you don't know what that means, have a look at it for it. I do encourage you to avoid the use of abbreviated language. So I didn't should be I did not, for example. And when you're referencing, make sure that you pinpoint reference as much as possible. All right, thank you for allowing me to address you on all of those things. Not that you have much choice, I just started to do it, whether you liked it or not. I think we might start on native title next week, but I'll just run through some of the basics. So next week we're talking about topic 7, which is state land in Queensland and native title. So what do we need to read? We need to have a good idea of what we mean by the grants of public land under the Land Act. Now, I mentioned earlier tonight the fee simple, meaning the best you can get, but it's not absolute. It's subject to reservations, and those reservations would have been included in the original deed of grant from the Crown, and the reservations would have been probably to do with minerals and petroleum. So have some idea of what we mean by the grant of public land. Have a look at the Land Act 1994. Some of the issues around universal and absolute Crown ownership, native title, we've talked about some of that tonight, radical title, the common law, how it deals with native title. The Native Title Act 1993 is important, and the Native Title, National Native Title Tribunal. So a lot of things for you to do there in terms of your reading. Right, before I wrap up for tonight, are there any questions, comments? All good? You've been, once again, extremely patient. Thank you. All good? All right. Thank you. For those of you about to go to evidence, have a nice evening, and otherwise we'll see you next week. Bye then.
Thank you.